Good afternoon, everyone, and welcome to today's webinar with Mr. Edwin T. Bell. The time is 2:02. We will allow our participants a few more moments to join us, and we will get started at 2:05. Thank you all again for joining us today, and we will get started at 2:05. All right, the time is 2:05, and we are going to go ahead and get started with today's webinar. And as many of as you all may know, that this is our second municipal justice sponsored by the Municipal Court of Stonecrest. And joining us today from the Municipal Court of Stonecrest is our Honorable Judge Curtis Miller, our court clerk Victoria Harris Ferguson, and also myself, which I serve as the court administrator and also the clerk of court. This series is really geared towards not only our citizens here in the city of Stonecrest, but to our court clerks throughout the state of Georgia, and anyone that is interested in engaging in important topics with the court. So today we have Mr. Edwin T. Bell with us. And throughout today's webinar, we are more than happy to have you all place your questions inside of our Q&A. At the end of today's webinar, we will be sure to get those questions answered to the best of our abilities. If we run out of time, we will be sure to answer those on the back end front for you all. So I'll be sure to get those to Mr. Bell. So again, we are very happy to have you all here. And before we get started with our introduction to Mr. Bell, we want to give our Chief Judge, Honorable Curtis W. Miller, some time to give us a few words. Judge Miller.
Okay, good afternoon, everybody. Thank you, Mallory. And I want to welcome all of you all to this series. It's so important that the people who have to use the legal system, and that's whether or not you're a victim, whether or not you're a defendant, whether or not you're a witness. But it's very important that everybody understands what the system is. As judge here in Stonecrest, I try to take a lot of time in explaining the law to the citizens because there are so many misconceptions about what goes on in the legal system. And considering that in this day and age, some folk feel empowered to criticize judges and other people involved in the system beyond what's normally accepted, it's even more important that we spend some time making sure that everybody is on the same page, so to speak. So again, I want to thank Mallory and my clerks for continuing to be on the forefront of this effort to make sure that citizens, every citizen, whether you're an employee, you're involved with the court system, that you understand how things work, and more importantly, have an opportunity to address your concerns or some of the misconceptions that you may have. All right, so I'm waiting to learn something, Edwin.
All right, thank you so much, Judge Miller. So without any further ado, I am going to go ahead and introduce our guest speaker today, and we are super, super excited to have Mr. Edwin Bell with us. Mr. Bell is an accomplished public sector executive with a distinguished career spanning over 25 years, and it currently serves as the Director of Racial Justice, Equity and Inclusion for the National Center for State Courts. I know that if you all are here with us from one of our local courts, very familiar with NCSC. Mr. Bell holds both Bachelor of Science and MBA degrees, as well as numerous court management certifications. The public leadership credential from Kennedy School of Government at Harvard University, and he is a fellow of the Institute for Court Management. Edwin's journey is defined by his visionary leadership. He possesses a rare ability to drive change, build impactful partnerships, and spearhead transformative initiatives. His unwavering commitment to justice continues to leave an indelible mark on the organizations in which he works in and with the community in which he lives. Mr. Edwin Bell.
Good afternoon, and thank you. I appreciate that introduction. Certainly extend my thanks to Judge Miller and to you, Mrs. Minor, and to Clerk Harris Ferguson for allowing me to be here today. And additionally, extending my appreciation to the citizens of the city of Stonecrest. I certainly appreciate being provided this opportunity to speak to everyone. And so I have a few remarks before I get into my general presentation. But I'd like to start off, you can see in my background, Blueprint for Racial Justice. And oftentimes I'm asked, hey, can I get a copy of that document? And I like to remind people that the blueprint is a collection of thoughts and ideas of people across all walks of life, all political backgrounds, who have said we've got to identify ways to make the systems of justice that we use, that we work in, and that people in the community are required to use to have their court or judicial matters handled. We want to make sure that the system is fair to everyone. And so you wouldn't build a house, you wouldn't build a courthouse, you wouldn't build anything without a set of plans called blueprints. So in a sense, we are all architects, we are all engineers working in different capacities to ensure that the systems of justice that we work in and that we're building are fair and equal to all people. So I'm going to get into my presentation. I'm going to share my screen. Bear with me just a moment. All right, you should see my screen and my initial page. So again, Blueprint for Racial Justice is an initiative of the National Center for State Courts, along with the Conference of Chief Justices and the Conference of State Court Administrators, along with a number of organizations and people. And we'll get to a little of that. There's so much that can be said about the work that's gone on that we won't be able to limit to this discussion today. And I want to make sure that we have an opportunity at the end for people to ask questions. And just know if you put a question in the Q&A portion of Zoom, if we don't get to it, I will respond to it after the session is over. And I'll also allow you an opportunity to connect with me one-on-one if you choose to do that. So the Blueprint for Racial Justice, as I indicated, is a national endeavor that's come together, and it sort of grew out of these changing judicial societal norms. And so here in 2020, here's an excerpt from Resolution 1, and part of that resolution reads, to examine what systemic change is needed to make equality under the law an enduring reality for all, so that justice is not only fair to all, but also is recognized by all to be fair. And there is the difference. We've seen that it's not enough to say that, oh, I'm fair, I treat people fair, or if I'm a judge, hey, I'm fair, I give out just sentences if it's a criminal matter, or fines, or whatever the case may be. We want everyone in this country to recognize themselves that the systems of justice that we're using are fair to all people. And essentially, this comes out of resolution number 1 from July 2020, the joint conferences there, chief justices and state court administrators. Now, to get this off the ground, we started this initiative about 3 years ago or so, and there were a lot of partner organizations involved, many more than are on the screen right now. We talked about those justice organizations. I didn't mention organizations such as the American Judges Association, the National Association for Court Management, the DEI Collaborative, and we'll get into talking about DEI in a bit, the National Judicial College, the National Association of Women Judges, the National Association of Presiding Judges and Court Executive Officers, the National Council of Family and Juvenile Court Judges, appellate judges. So essentially, most of our mainstream organizations that have members who work in or touch America's judicial systems are represented within the construct of this blueprint for racial justice. Over 150 people, now that number's grown to over 200 people, have been involved in various capacities. And I'll talk a bit about how they've gotten themselves involved. So I always talk about navigating change as if it's like a boat, right? So if we have different streams of water. We all know that. If you're at Stonecrest, Stone Mountain's not too far. You've got lakes there. You go up to other lakes further out, whether it's Lake Lanier, or if you want to go to Lake Hartwell, or if you're going to West Point Lake, or wherever you're going, you have to navigate things. You don't start an initiative or have an idea and not realize that anything you begin is going to have some challenges aligned with it. But in thinking of these challenges, we identified a few key target areas that we thought would be important. And some of those include the first one you see there, fairness and awareness. That resolution number 1 that I spoke about is about fairness. and awareness. People need to feel as though whatever the resolution is to their court matter, that it was fair. And there must be some awareness or recognition on their part that it was fair. It's not enough. It's not enough to say, oh, well, I was fair, we were fair, and oh, well. Um, I think that's the easy route that many people, well-meaning people, that's the easy path they take because working to ensure that the very people that you serve feel as though things are fair is difficult. And most people don't want to take the time to put measures in place so that people can feel as though they got a fair outcome. The other thing we talk about here is systemic change. Systemic change, the other word for that is institutionalized change, meaning those aspects of the work we're involved in courts that are baked in. They don't just change overnight. If court's at 9 a.m. and there's 75 people on the calendar, then all 75 people show up at 9 o'clock in the morning. That's a systemic or institutionalized way of doing business. I'm not here necessarily to be critical. I've been a part of that system for many years. But is it fair to everyone? Is it fair that if the people who have an attorney get to go first? That happens all the time. And quite frankly, that's the norm in many courtrooms across this country. Is it fair to the people who can't afford a lawyer? That they have to sit and wait? Is it fair that their case gets rescheduled for another day because the judge and the judge's courtroom staff, quite frankly, didn't have the ability to hear all of those cases? And so the very people who can't afford lawyers and quite frankly might not have a job that offers paid time off have to then take time off and come down again. Is that fair to them? I don't know that it is, but that's a systemic way of doing business. Doesn't matter what you look like, doesn't matter what neighborhood you come from. This is how we do things. And even as the personnel changes, as I leave the court, or as anyone else leaves the court, or if the judges leave and retire and move on and someone else comes in, those systemic things continue to happen irrespective of the office holder. And so we want to take time in our processes to identify those items that we should bring further attention to and determine whether or not there are practical ways to make improvements across this country. The third target area, improving diversity of the bench, the bar, and the workforce. Now, for those who are unfamiliar with some of those terms, the bench, we're talking about judges. When you hear the bench, we're talking about people who are judges. When we talk about the bar, we're talking about lawyers. And when we talk about the workforce, we're talking about the people who work inside of courthouses around this country, whether it's Stonecrest, whether it's DeKalb County, or any county or any other city around the state of Georgia and around the country. That's what we're referring to. So when we say improving diversity, what we're talking about is having people who mirror the communities in which they serve. And that cuts both ways because generally what we see happen are if someone comes from that same community or mirrors that community, there's an understanding that can only be gained by coming from a particular community. It might be a very minor, a very subtle understanding, but it's an understanding of that community nonetheless. And when you have people who are judges that come from various communities, when you have people who are attorneys that come from various communities, when you have people who work in your systems who come from various communities, your outcomes often are better because you won't necessarily have as many of those gaps in knowledge and understanding that can be misinterpreted because people just quite frankly come from different communities. And then we had communication and implementation. In this group, we created this group because we wanted to as ideas were developed by the other three groups, we wanted this group to identify ways to communicate the some of the uh, programs that come from the various groups that we think could be used by court systems around the country. So how do we communicate this information? If we develop something, and I'll get to, for example, our assessment tool, but if we develop something, how do we then communicate that item that was developed that we think is a good thing to the court systems around the country? How do we communicate it so that they know? It doesn't make sense to develop something and then only you know about it. The purpose here is to create and let loose so that other jurisdictions can have an opportunity to put some things into place and use some of the best practices that might have been identified by people who have served on these various committees. So I'll jump back to fairness and awareness. So there are different things here, not in any particular order, but for example, I talked about an assessment tool. The first thing I was asked for when I started with the National Center for State Courts was to create some sort of a tool that judges and court leaders could use to understand whether or not they were serving the people internally and externally well. And what I mean by that is well under the guise of both race and diversity. Oftentimes, many of you know, our judges are isolated from the general public, with the exception of when they're just out on their own time. And there are a number of reasons for that. For one, it's just safety and security. And so when information gets to a judge, oftentimes that information is filtered. So judges don't always realize how they're being perceived by people who come before them or by the very people who work for them. And so we developed this tool that is anonymous, it's free. And what happens if a court decides to assess themselves, it will generate suggestions based upon the answers that go through this algorithm process. I think it's a very, very good tool. And quite frankly, I think that all courts should use it. It doesn't cost a penny. It just takes a little bit of your time. And I'd be willing to give some technical guidance on how to use such a tool. But the other thing through this fairness and awareness group, data standards and reports, many courts do not collect race or ethnicity data. And there's a number of reasons for that, especially out when those cases do not have to do with traffic or criminal offenses, which in Georgia is one of the few states where traffic offenses are crimes by statute. A lot of states, traffic offenses are not crimes. And so if they're not collecting the data, you can't definitively say whether or not there are trends or patterns being identified in how fines and fees or dispositions are being handled. Oftentimes, there's just a hunch or a guess. The problem with the hunch or a guess, it's biased based upon what the person thinks of themselves or of the organization in which they work. And so there are a number of things that have come out of this group that I think are good for individual court systems to use. Now, same when you hop over to systemic change. Remember, I talked about systemic change are those changes that alter what's been baked into how we do business. Courts, hey, we have court 9 o'clock a.m. Monday morning. That's a systemic way of doing business. That's how things are done in many courts across the country. I don't care where you are, at 9 o'clock somewhere, court is starting. Doesn't matter if it's a municipal court, a magistrate court, a juvenile court, a probate court, a superior court. It doesn't matter. Court is starting all across this country at 9 o'clock in the morning in most places. And so we have to identify whether or not that's the best way to do things. And so in systemic change under that work group, they were looking at different ways where they could make adjustments to how business is done, adjustments to how warrants are issued. There have been many high profile warrant problems where law enforcement has requested a warrant of a judge approves the warrant, and then there's been some outcome that's been not just unfavorable, but quite frankly, scary and dangerous and sad because warrants, by some people's opinions, are given out, quite frankly, too easily without enough information being provided on behalf of law enforcement to our judges so that our judges can continue to make sound decisions. And before, especially if we have any law enforcement people on here, I have been in law enforcement, so I'll start by saying I know what it's like to go get a warrant for a judge, and for the most part, it's very easy. Anybody want to challenge me on that? I'll be happy to talk to you after this. But that's an area that has brought forth a lot of concern, both in Georgia and nationally. Jury selection and service. You know, we talk about a jury of your peers. In some communities, the word peer, it's ambiguous at best. We don't know what a peer is. It's just whoever shows up that day, and then whoever decides to show up who gets selected. If you're an attorney, more than likely you're going to get booted off and you're not going to be able to serve on the jury, even if you wish to. Although there have been some high profile cases where they've allowed attorneys to serve, including one case that started this morning in New York. Other things such as plea bargaining, how that gets done, that's a prosecutor driven model. Expungement, how do you get rid of things off of a person's background if they qualify to have that record restricted or expunged? Something that is systemic that we need to work on. Same with fines and fees. This does not apply to the city of Stonecrest, but quite frankly, there are a lot of cities that live off of fines and fees. They live off of fines and fees. Instead of raising taxes, they would just tell the police chief privately to go write a bunch of, get the police chief's team to write a bunch of tickets, because that's how you're going to fund city government. There are a lot of problems with that. And I know that happens because I've been in the room. So no sign for debate there. But the United States Department of Justice issued a Dear Colleague letter several months ago to remind all state Supreme Courts, so that they remind all of the lower classifications of courts in their state that the ability to pay must be considered. And I think sometimes there are courts that forget about that. And yes, most of our judges are attorneys who are members of the bar. But again, some of these practices and ways of doing business are just baked in. And many of us don't necessarily pay attention to it or realize it because we're just in the business of working and running courts around this country. But that's a very, very important area that has to be considered. And we've already started along the path of trying to identify ways to work with courts to adjust how fines and fees are being levied on people. And to be honest, the majority of people who can least afford it. You want to levy a fine and a fee on me or even Judge Miller, sure, we'll take care of that. But quite frankly, the average person doesn't have the money. They get looped into a cycle of probation, and they pay many times over what they should pay based upon the manner in which they had been charged. So I'll move on. So there are some guiding principles that we identify that we feel as though all courts should take into consideration just in general court operations, or as they look to make adjustments to how they conduct business. I'm going to read these. There's 7. They're very simple, and we have a guide on the National Center website and our resource center where we have more detailed information. But number 1 is any systemic change you decide to make should truly be systemic. It shouldn't flow with the winds. For example, if the chief judge of a court leaves, any reason, they retire, they decide they're ready to move on to do something else, the changes that were made should not leave with that chief judge. If it's that easy for change to be done, then that means that it wasn't systemic or institutionalized, and it quite frankly didn't have enough teeth. So when you decide to make a change to how things are done in your local court system, you have to really think long and hard about what systemic change is. The other thing is that all of your changes should be transparent. Yes, there will be some private discussions and meetings about what areas should you tackle first, because you should take a strategic approach to making adjustments to policies and procedures, and quite frankly, even traditions. But they should be transparent. There should be some opportunity for the general public and the community to weigh in on some of the changes that you're hoping to make. Many times when we don't provide that opportunity, when it comes out later, we run into some strong headwinds from people in our local communities because they feel as though things were done in a surreptitious or, quite frankly, a shady way, even if that was not the intent of the very people who are working to implement systemic change. So make sure any changes you implement to benefit the people who work in your systems and who have to come into your systems, make sure that they're transparent in nature. The other is that when you make a change, don't make change for change's sake. Make your systemic changes because you are intentionally meaning to do whatever it is you're trying to do. You have a specific purpose, and that the changes are dynamic. So everyone understands intentionality, right? You have to be intentional. You did something, you made a change because you identified an area of concern and you wish to adjust or fix that, right? That falls directly in line with the purpose for it. There's a real purpose. You didn't make adjustments or changes to whatever it is you're dealing with because maybe one individual person wanted something changed, that there's been some wholesale discussions and strategy surrounding the purpose for why you want to make a change happen. Change shouldn't just happen because you want to make a change. And so therefore, when you leave, everybody can say that, oh, he or she made this change. That's not the purpose. The purpose is to identify or rectify a potential concern or a real concern that's come up. And then the dynamic part means any change you make doesn't necessarily mean it has to live forever. You may have to make adjustments to those changes over time. So as laws change, we have to make adjustments. As community sentiment changes, we have to make adjustments. And on rare occasion, when the key personnel changes, you have to make adjustments. Okay. Next, and this goes to transparency. Systemic change should be stakeholder and community inclusive. So stakeholders, that's everybody who has to touch the system, has to deal with it, has to work in it. You need to make sure you get their perspectives before you make changes to your system. And then community inclusive means the people that it's going to impact, there should be a way that they have a voice in understanding why we're wishing to make changes to our court systems. It doesn't always mean that you either do or do not make changes based upon some of these the communications that you have, but you should at least be able to listen and understand other people's perspectives. Because when you work in the system, you have some knowledge and understanding that, quite frankly, other people who do not work in the system, that they do not. And so you want to make sure that you're being very clear. And one thing I'll say is change doesn't have to happen fast, but it shouldn't be as slow as a snail either. But you want to make sure that people have been given an opportunity to weigh in on any changes that you wish to make, because that's the fair and the right way to do things. Next, any change you make should be tailored to your community. Since we're here with Stonecrest, I'll say what works in Stonecrest, quite frankly, may not work in Lithonia, might not work in Stone Mountain or the city of Decatur. So you don't necessarily, so what someone else is doing elsewhere may not necessarily be what you need to do in your community. That's why we say any systemic change you make needs to be community tailored. It's like a good fitting suit, right? What I wear is going to be too big for some other guys because I'm a bigger guy, right? So you want to tailor it to your community. And then last, the systemic changes should be informed by data and then subsequently evaluated. When I say informed, I don't mean it should be necessarily driven by the data, because sometimes you can have data, it can make you think something is really a problem or is really a good idea, but in actuality, it only benefits one person or two people, like in reality. So it should be data informed, meaning you've looked at certain data that's available to you in your court and into your community. And based upon the merging of the two, you've made a decision to make adjustments to various aspects of how you do business, any particular uh, policy actions and such based on the data that you have. So you're not just using your gut, because unfortunately, our gut instincts are biased to us and how we see the world. And it doesn't always mean that we are right. And then when I talk about evaluation, once you put changes in motion periodically over a period of time, you need to conduct surveys, you need to evaluate the benefits that have occurred for the changes that you've made. And I'm saying benefits, assuming that all of the changes are positives. But there could be circumstances where you've made changes and unfortunately the outcomes weren't quite what you expected. Okay. So increasing the diversity of the bench, bar, and workforce, I talked about the bench, that just means judges, the bar, that just means attorneys, and then the workforce, I mean, those of us who work in courthouses all over America. So there are a few things that have come up. I'll start with the strategic planning guide from the state of Delaware. For many of you that don't know, Delaware is probably the #1 state in America for corporate entities to be created. Those of us that live in the Atlanta area, we think about Delta Airlines. Delta Airlines legally is housed in Delaware. And there's a reason for that. Delaware is a very business and corporate friendly state. And you can hide a lot of things under the corporate veil in Delaware that you can't in many other states. But what they found in Delaware were that even though it's a small state, they had very small numbers of people who were non-white that were attorneys and judges in that state. And there are a number of reasons for that other than just population. But one of the reasons were that state, they don't allow you to practice law in that state if you've not taken the bar in that state. Well, that eliminates a lot of people. And the bar exam is just a test, for those of you that don't know, that lawyers have to take and pass in order to be a lawyer and operate in a particular state. Well, in Delaware, if I pass the bar in Georgia, I can't go to Delaware and reciprocity my way in, because I have a license in Georgia. I've got to take a full test. So that automatically knocks out a lot of people up there in their state, in the Northeast or New York or what have you. They're not able to go over there and practice law. So what you find is that it's a certain niche group of people who are able to function in that jurisdiction. And so they decided that they needed to make some adjustments to that. And they did a study, and they're underway with trying to change how people are allowed to practice law in that state because it's better for that state. Just because you allow more people from various backgrounds to enter a particular workforce doesn't mean that's bad. It doesn't mean that you're lowering the standard. Okay? It doesn't mean any of that. It just means you've allowed people additional opportunity. Because The reality is, if a person's a lawyer in Georgia or California or New York or Texas or Alabama, Mississippi, Kentucky, Missouri, Idaho, they probably could be a good lawyer in Delaware. So you're not lowering the standard. But what we know is when certain groups of people are negatively impacted, that means their minority groups often are impacted even more. So we're not talking, because sometimes we hear, oh, you want to lower the standard. No, no, we don't want to lower standards. We want to give people an even playing field. And it's not even if the system is set up to where only a chosen few are able to play on that field. The other thing we talk about increasing diversity, and this is of the bench, we talk about quasi judicial appointments. So let me explain what I mean by that. Talking about a person who gets to be a judge because they were appointed and not that they ran for office. Many of us know in Georgia we have a lot of elected offices, but we have a lot of appointments too, where the city council gets to appoint people, where if you're in juvenile court, you don't run for office except for one in the state of Georgia who is elected, but the rest of them, you're appointed by people to serve. Or if you're a busy judge, you're pro tem. There's an order. You get an attorney to come sit for you because you're going on vacation. They wear the robe. They're called judge. Those are quasi judicial appointments. And we talk about that being a pathway for people who ordinarily might never have an opportunity to serve as a judge, to gain certain experiences. These are the ways where people who are called judge, that many of members of our community do not realize that they're not elected office holders. They see them as judge. They call them judge when they're in the courtroom. And so it's important for many different people from many walks of life to have an opportunity to serve in these communities. And this is one way to do it. If the decision is that the only way you should be able to serve is to run for elected office or for the governor to appoint you, then I can tell you now you won't have any change. Very, very small numbers of people will be able to serve and represent the communities that they come from if that's the only pathway to the bench. And then you see we have the National Intern Project, the National Extern Project Pipeline Recruitment Efforts, CORA, Court Opportunity Recruitment for All. If you are an attorney or an aspiring attorney and you want to serve as a clerk at the federal level, there's a system called Oscar that you're required to apply through, everybody. And this system is how the federal judges get to pick who's going to work for them as a clerk. So what I decided to do, I said, listen, let's create a system that our state, county, and city courts can use to put not only law clerk jobs, but court administrator jobs, clerk of court jobs, court clerk jobs, director this, director that, deputy director this, chief that, anybody that has to work in the court system. I said, we should create a system for that. And we did. And it's called Cora, and it is live right now. So if any of you have jobs that you want in Cora, reach out to me. I'll make sure you get connected to the right person. Because what we have seen in a short period of time are applicants from all over the country outside of the lower 48 states, including Alaska, Hawaii, and all of the territories. It's given them an opportunity to look for opportunities here in the lower 48, so that otherwise these courts might not have had an opportunity to reach these people. It seems very simple, especially in the age of the internet, that, well, if somebody wants to work in Georgia, or if they want to work in Alaska, they could just get on the internet and do it. Yeah, sounds simple, but the reality is that that doesn't necessarily work that well. So we've created Cora as a better complement to the federal system called Oscar. Now, I talked about the community communication and implementation work group before. Some of the things that work group would work on and try to connect our court leaders with are community engagement plans. Most courts don't do anything like Stonecrest. Most don't do anything whatsoever, never have, some never will, with respect to community engagement. It's just how they're set up. It's just how it's always been. One of the things we hate to hear employees say, well, we've always done it. Um, and so there's very little community engagement. Well, if you want the people in your communities to feel as though you hear them and that you're going to be fair to them, you got to engage with them periodically. Some people say, well, we did it one time 10 years ago, and it got into a shouting match, and we had to have our local police there and our local sheriff. Well, it's like anything else, like a pressure cooker. If you just wait every once in a blue moon, people have got 5 and 10 years worth of anguish, and now you're here and you're going to hear about it. Probably not that productive, but you got to start somewhere. And, quite frankly, our judges are often very strong people, character-wise. And, they may not like it, but it kind of comes with the territory. Same for our court administrators. You have to deal with it. But not enough courts engage in community engagement because, quite frankly, they don't think they have to. That's just me being real with years of experience. Communication plan and hotline. One of the things that court leaders have to do, and I'm talking about our court administrators, court executives, district court administrators, court executive officers, we have to plan for emergencies that come up, but we also have to plan for the proverbial foot in the mouth that some of our leaders unfortunately do. And so we've created a hotline where if a jurisdiction doesn't have professional communications personnel, if they've had a circumstance in their court that's really bad, a judge has said something, got caught on a hot mic, expressing his or her differences about a circumstance, they can call through this hotline and get some help on how to respond to a community concern. That's very important because many, 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 many courts don't have people on staff who are professionally trained at dealing with the public, other than those coming into and out of the courthouse. But I'm talking about dealing with the media, dealing with internet media, social media, dealing with the television stations and newspapers. Oftentimes, because we can in the judicial area, we just say no comment. Well, the reality is no comment isn't always enough. And so those courts that need help, we're providing help to them if they want it. And this group is also, we provide links to different studies on our website that could give them an opportunity to understand what's happened elsewhere and give them an opportunity to see whether or not studies that have already occurred are beneficial to them. They're also linked to state diversity, equity, and inclusion commissions. And what those are, many Supreme Courts created these committees or commissions to study whether or not there are issues pertaining to diversity that need to be addressed. And so there are commissions or committees that have been created, and we have links to all of those on our website as well. We also have our DEI officers group. There are about 45 people around the country who specialize in diversity, equity, and inclusion, and who work within courts to ensure that policies are developed and to help to improve the engagement with people, both internal to the organization, to court organizations, and external to communities that we serve and work in. We also have our resource center online at ncsc.org/racial justice. We've done a number of webinars from no-knock warrants to pretrial supervision and probation. We do a quarterly newsletter where we highlight certain activities that we think are important for people to know about. We also have a speakers bureau. As I'm here speaking today virtually, if there are topics that you wish to consider and would like to have someone speak at your event, we try to work to identify an appropriate person for you. And then lastly, we do offer some technical assistance. I mean, the National Center for State Courts is a nonprofit, but we're a unique nonprofit. We were created over 50 years ago by the United States Supreme Court and the 50 state Supreme Courts, as well as the territory Supreme Courts jointly. So we're a unique sort of organization. And we offer various services to courts and other organizations that work within justice systems. And so if anyone in need of that type of assistance, uh, I could certainly point you in the right direction. But primarily, our primary focuses nationally um, tie into what we've just discussed. And of course, this DEI, the bench. We talk about pipeline. All that means for those people who aren't who don't work in courts or the legal community, it's just running people through. It's kind of like if I'm a plumber and I know plumbing, I can get young people through to that trade. If I was an electrician, same thing. It's just, you know what you're doing. You see some people coming up, young people wanting to get into that business, you bring them through. You work them through. You show them the ropes. Each one teach one. You have to teach people how to do things. You can't look up one day and just expect people to know how to do this business. So we work in this particular area. Same for court personnel. A lot of emphasis is placed on our judges, who we certainly respect, and they have a hard job. But generally, the reality is it's the court personnel who run court systems. They make sure the lights are on, making sure people are being paid, making sure security is in place, making sure that citations are being processed, files are being properly taken care of. Those are court personnel. The judges don't do that. They're on the bench. They have to make decisions based on the facts that have been presented to them, as they are fact finders. But court personnel, we run the court systems. And then certainly a focus for us is data analysis. There have been national standards for years. And there are ways in which, if you're not already collecting race and ethnicity data, we have people on staff to show you how you should go about collecting that data. And then from there, training efforts, we do all sorts of training. Generally not for the community at large, but certainly for court personnel and judges. Any aspect of court life that there's a training need, we provide that need. And then certainly community and engagement. Again, I said most courts do not do much community engagement at all. Some that do very little, but most don't do any. So we know that can be a scary thing if you've not been involved in that. We have professional people on staff that can help guide courts and their leaders with doing engagement, so that the people who have to use our systems and their families, and the people who work within our systems, begin to recognize that we truly care. We're real people. If you're a judge and the judge is wearing a robe, that's a real person. Judge Miller's a real person, takes that robe off, is in the community as much as anybody else. Mallory Minor is a real person, has to, outside of work, is out here in the community like anyone else. And so we like to offer our services where it makes sense. So I'm gonna wrap up at least here and be ready to take some questions. I'll stop sharing my screen, but if you need to get in touch with me, there's my direct phone number and my email address. And I'm willing to engage with anyone. So I'll stop sharing my screen, and I'll let Ms. Minor take over.
All right, so we are back, and I truly enjoyed that presentation. We certainly enjoyed that candid discussion of those particular topics and providing that blueprint for social justice, for racial justice, my apologies. We don't have any Q&As inside of the chat. However, I did receive a few in advance, and I would like to read one before we adjourn for today. And I do like to take the opportunity as I pull up our questions here that were received via email to courtinfo@stonecrestga.gov. So if you all have any additional questions that you were not able to put into the Q&A, you can always email those questions to courtinfo@stonecrestga.gov. And I definitely want to recognize our GMCCC court clerks that have attended this event with us today. I do see Miss Sherry still with us, Nathaniel, she's with us, and also Miss Trina. and of course, our GCCA partners. Our Madam President, Lenore Hawkins, is with us. Our Vice President, um, Tim Ezell, he's with us. Thank you all. And we also had TJ with us, and I know that he has a presentation in which he is going to be on momentarily with NACM. So we just appreciate you all's support. So Ms. Robinson of the Superior Court Clerk's Office here in DeKalb County, she would like to know, how are courts handling sentencings and equities or guidelines?
Thank you for that question. I believe so. A couple of different ways. There are some court systems, for example, when you talk about inequity and how a person, and I'm assuming she's speaking about criminal matters since she said sentencing. Some are revisiting sentences that were given out depending on a couple of ways. One, if they've been petitioned by the person who was sentenced, or if a law has changed, or if the state or federal Supreme Court has issued a ruling which will require the local courts in a state to revisit all of the sentences that have occurred given a particular statute. So how they're handling it varies. That's not an easy question to answer. It really varies. It just depends on what the crime was, and then whether or not either federally or at the state level or at the individual level, the person who was convicted of the crime sought to have their conviction reviewed. If, for example, they find out they got 10 years in prison and somebody else who did the same thing only got 5. So it really varies. It just depends on the circumstances.
All right, thank you so much. And do we have time for another question?
Sure do. I've got nothing but time. I want to be respectful of your time, but I'm available.
Okay, so just one more question. In your experience, how have you attempted or implemented inclusion at your place of work during your time in court administration? As we do have a lot of court leaders here with us, and hopefully we can learn, based upon some things that you've done in your tenure as a court administrator.
Well, under my previous life, we'd had a couple of opportunities to um, survey personnel about their thoughts and feelings about how things were occurring in court administration. In fact, if we go back to 2016, I was working on a ICM fellow paper, which required that I conduct interviews and surveys of personnel in court administration. Because again, sometimes those of us at the higher levels may become disconnected from everyone else who works in the building, especially if you're talking about an organization that has a couple of hundred employees scattered about the building and in other offsite locations outside of the primary courthouse. It becomes really easy to not realize that they feel that you're disconnected from them and that things are in place that are not fair. So you do surveys. There are survey instruments that are available for free through the National Center that allow you to survey people because you like to get I call it the temperature of your work environment. And oftentimes when you're the boss, you're not really going to know the temperature of your work. You might think you do, but the realization is a lot of people are uncomfortable with coming to the court administrator to express some of the specifics of their concern. You get wind of things here and there, but a survey instrument is the best. We've conducted surveys, and surveys go a long way as to, well, how do we handle work hours, especially coming out of the pandemic? Do we still allow for remote work? If we're allowing for remote work, are we able to serve the constituents and the people who have to come in if we physically don't have the staff in the building? Surveys also allow you to determine if certain processes are outdated. We don't always know that if you're in the top leadership position. You know, we could have extra work being done by personnel that really doesn't have to happen anymore because laws have changed, other policies have changed that directly impact how we do business. And so I've been able in the past to using survey instruments to broadly identify where some sticking points were for people and make recommendations to other judicial leadership about how to make adjustments to those areas that were of concern to staff and also to people, court users who have to come in the building every day.
All right, thank you so much for that detailed response. So we are going to close there. And again, I would like to thank everyone that is in attendance today for joining our second Municipal Justice Speaker Series. We do have two more series during 2024, in which we hope that you all join. Mr. Bell, it has been a pleasure.
Thank you.
Being here with you today virtually. And we appreciate your recognition and our efforts to engage with our community. And we hope that we continue to encourage other courts, no matter what level of court in which you serve as a court leader, to continue to engage your citizens and also your community. And we could not do this without our support of our Chief Judge, Honorable Judge Curtis Miller. And also, I could not do this without the support of our court clerk, Ms. Victoria. So again, we appreciate you all. Have a great day. Thank
Thank you,
you.
everybody. I appreciate it.